My name is Nick Gebelt. I'm an attorney here in Whittier. I'm a board-certified bankruptcy law specialist certified by the California State Bar Board of Legal Specialization, and I also do tax debt resolution. In this video, I'd like to discuss something that comes up with some regularity in Chapter 7 bankruptcies. That's reaffirmation. Now, in order to understand the idea of reaffirmation, we need to set the stage. The context generally involves a secured debt, the secured debt being a debt that's secured by some tangible asset, perhaps a car or a house. I practice in the Central District of California, and because of the predilections of the judges here, we really don't have reaffirmation for real estate, but we do frequently have reaffirmation for cars. So what's going on here? Well, let's take a couple of steps back and find out what happened when you bought that car. You went to the lot. Liked the car that you saw, so you decided, yes, I want to get that one. And the dealer said it was $25,000, and you reached in your pocket and found no $25,000. So what did you do? You took out a loan. When you took out that loan, two things happened. Now, they happened simultaneously, so you might not have been paying attention to these two things as discrete concepts, but they happened nonetheless. Number one, the creditor who lent you the money got a security interest in the motor vehicle. What does that mean? It means if you don't make the payments, the creditor can retrieve the car. What have I just described? I've described a claim against the car, and the car is a thing. In law, we refer to a claim against a thing as an in rem claim. And the reason, little arcane, it's because the Latin word for thing is res, and in the appropriate objective case, it's rem. The second thing that happened is you as a human being became personally liable on the debt. What does that mean? It means if you don't make the payments and the creditor repossesses the car and sells it for less than you owe that post-resale liability. So that's a claim against you as a person, and in law we refer to that kind of a claim as an in personam claim. Now when you go through a Chapter 7 bankruptcy, the big picture goal is to get rid of debts. And what we're doing in that Chapter 7 bankruptcy is getting rid of in personam claims against you. So if you take no further action, the creditor, if it repossesses the car and sells it for less than you owe, cannot come after you to collect the post-resale deficiency, because in that Chapter 7 bankruptcy, the in personam liability is extinguished. Well, you can imagine that creditors don't like that, and so they paid hundreds of millions of dollars to a large number of politicians in Washington, D.C., and they got the law changed in 2005. Now what the law says is, if the creditor wants to, it can insist, as a condition for you keeping the car and continuing to make those regular payments, that you must resurrect that in personam liability against you. And if you refuse to do it, if the creditor wants to, it doesn't have to, but if it wants to, it can repossess the car even if you're current on the payments. Well, that process of resurrecting that in personam liability is called reaffirmation. Mechanically, what happens is the creditor, if I'm your attorney, will send me a reaffirmation agreement once it finds out that you filed for bankruptcy protection. We will meet after the 341 meeting of creditors in the hall, and we'll go over the terms of the reaffirmation agreement. If you're comfortable with its terms, you sign it, I send it back to the creditor, and the creditor's representative signs it and files it with the court. Then the judge assigned to your case will set it for a hearing. If you refuse to sign the reaffirmation agreement, the creditor can repossess even if you're current on the payments. There's a case, a Ninth Circuit Court of Appeals case called In re Dumont that holds that. If you refuse to attend the reaffirmation hearing, the creditor can repossess the car even if you're current on the payments, because you didn't comply with this requirement in the bankruptcy code. However, if you attend the hearing after having signed the reaffirmation agreement and the judge assigned to your case says, I don't think this is in your best interests, I'm not going to approve it. Then, when you emerge from your Chapter 7 bankruptcy, that in personam claim will be gone. Now, the in rem claim still remains. You're not going to get a free car. But if you don't make the payments because of some change in your circumstances, perhaps a job loss, a healthcare catastrophe, and the creditor repossesses the car and sells it for less than you owe, if the judge didn't approve the reaffirmation agreement, you owe nothing. Now, the creditor cannot repossess the car if you signed the reaffirmation agreement and attended the hearing, and the only reason that there isn't a reaffirmation agreement in place is because the judge refused to approve it. So, if you're having difficulties making the payments on the debt and you attend the hearing, one of the things the judge is going to ask you, in some guise, is do you have enough income after covering your other living expenses to make the payments on this debt? And if you really don't, that's the time to tell the judge, Your Honor, I'm having some real difficulties here. At that point, the judge will not approve the reaffirmation agreement because the judge doesn't think it's in your best interest. Then the in personam liability is extinguished when you get your discharge. Now, some creditors will put a little sweetener in the pot. They'll say, well, if you reaffirm the debt, we'll make regular reports to the credit reporting bureaus telling them of your on-time payments. And if you reaffirm the debt, we will send you regular monthly statements. So if you're the kind of person that needs those monthly statements, that prompting to remind you to make your monthly payments, then reaffirmation can be useful. And if rebuilding your credit is something that you feel is absolutely crucial, then having the creditor make those reports to the credit reporting bureaus can be useful as well. However, if you're way underwater on the car, in other words, you owe a lot more than the car is worth, and the creditor refuses to reduce the balance in the reaffirmation agreement, then if you're getting that debt reaffirmed, you're paying a premium on top of whatever it is that you owe for the benefit of having those monthly statements and the benefit of having the regular reports to the credit reporting bureaus. My own sense is generally if you can avoid reaffirmation, it's probably better than doing the reaffirmation. If you have questions, I can always be reached at 562-777-9159.